In fact, this is a session which was ought to have been completed last Saturday, because we had the session of Imba Vijay and Veera Raghavan. I could not fit in for the time slot. Therefore, we have the session separately. My topic, our topic for discussion is principles of arbitration, duties of arbitral tribunal, and duties of the parties in arbitration. In fact, in order to understand these concepts of we need to understand the background under which the arbitration law was changed across the globe in 1996. As you all know that unsitral model law is the law relating to procedure of arbitration, which has been adopted by the member states of UN based on the recommendation of the UN General Assembly. We have at least 118 jurisdictions in the world having unsitral model law. India has a reading of the Arbitration and Conciliation Act will give you a clear understanding, in the sense that if you read the preamble, you will understand that the preamble says that we have adopted the model law. The Conciliation Act of India is having three parts. The first part is a copy of the model law. Second part is a copy of the New York Convention and Geneva Convention. And part 3 is a copy of the conciliation rules of unsitral conciliation rules. Therefore, we did not have much difficulty in making this law. The problem arose a little later. In 2014, we have two law commission reports. If you have an opportunity, please read the law commission report of 2014. There are two law commission reports. Following the law commission report, that we had amendments in 2015. One is 246 report, which suggests amendments to the Arbitration Conciliation Act. And you that we have a supplementary report to this 246 report, which speaks exclusively about one concept, and that is about the public policy that is contained in section 34 of the Arbitration Conciliation Act. A reading of that report will give you an idea that copying is not good under any circumstances, and even if it is done by Parliament, it is not good. You should have to apply your mind before doing something. This application of mind happened in the case of England. That is why we thought that we will speak about English Arbitration Act today. England had their own independent arbitration act in the 1996 itself. And the most interesting thing is that their arbitration law is a very detailed law, which has totally rejected the unsitral model law. And I think that in the report itself, the result has been mentioned. It says that in 2013, the revenue generated by that country from legal service industry, including arbitration, is 11.5 billion pounds. In terms of VAT and other revenue, that is the amount that was just because they applied their mind when an arbitration law was asked to be made. So I am trying in this, I have sent a small note, and in this session, we will be just talking about the principles of arbitration, duties of arbitral tribunal, and duties of the parties, the consequences for not following the duty by the arbitral tribunal or by the parties. These provisions are contained in the English Arbitration Act, and we will try to find out whether these concepts are available in the Arbitration Conciliation Act 1996. This is our attempt today. Why are we trying to understand these concepts? Because last time we were mentioning that Section 19 says that the Code of Civil Procedure or the Evidence Act is not applicable. So in a scenario where there is nothing to guide you as an arbitrator or an arbitral arbitration counsel, how are you going to be guided with? When we say in Section 19, there is nothing to be guided, we will understand that there is a provision in the English Arbitration Act which gives in detail how the arbitrator should be guided in matters of procedure and evidence. You have, it's a textbook type of thing, and if you have an opportunity, definitely we will have to read the English Arbitration Act if you are planning a career in arbitration. Therefore, my point is that United Nations itself wanted similar type of procedural laws across the globe. Therefore, they have created the model law, requested the member states that when you make your national laws, please adapt, adopt, or get inspiration from this law and make your own law. And some countries have adopted, some has adapted, some has taken inspiration. So I will take you to the UNCITRAL model law. This is the basis and I should also tell you one more thing before we proceed. That is, during the time of globalization, cross-border disputes became very predominant. National courts were unable to resolve such disputes. For instance, I had an occasion when a person came to my office saying that I had a contract with a person in China, and he was supposed to get a the contract was for supply of aluminum scraps in Kochi from a port in China. So the first consignment has come. Thereafter, it did not come. There was a dispute which involved something like 8 crores of rupees. And he had a contract and he was seeking advice as to what should be done. In fact, there was a dispute resolution clause which contained in the contract, but the dispute resolution clause was not an arbitration clause as such. It was something like a mediated settlement or something like that, which is not enforceable either in India or in China. And China does not enforce Indian decrees because we don't have a arrangement. And ultimately, I said that going to a civil court will not help you because there is no reciprocal arrangement between China and India. They don't enforce even US decrees, not to speak about India. So finally, what he did is that he went to China, went to some police stations, he tried his best. Finally, I found his face punctured. When he came back, somehow he managed to get some relief, not through the legal sources available. But in that case, if there was an arbitration agreement, India and China are signatories to the New York Convention. Therefore, enforcement is two things will automatically happen. One is the member states who are signatory to the New York Convention will recognize the arbitration agreements and also enforce arbitration awards. So you could have invoked the arbitration clause, you could have approached the Supreme Court, requested the Supreme Court to appoint an arbitrator, have the arbitration completed, get the award from the arbitrator, and you have enforced through the national courts in China. So it is the importance when the cross-border trade improved. UN itself has taken the initiative for making a model law and requesting the states to have the model law. The model law is designed to assist states in reforming and modernizing their laws on arbitral practice, taking into account the particular features and needs of international commercial arbitration. It covers all stages of arbitral process, from the arbitration agreement, composition and jurisdiction of arbitral tribunal, and the extent of the court intervention through the recognition and enforcement of arbitral award. It reflects worldwide consensus on key aspects of international arbitration practice, having been accepted by states of all regions and the different legal and economic systems of the world. So this is the scope of the model law. And as far as I have just copied the preamble in brief, if you have the opportunity, preamble to the Arbitration and Conciliation Act, it says that we have copied part 1 from model law, part 2 from Geneva Convention and New York Convention, and the part 3 from the conciliation rules. That is how we have made this law. And we have the English Arbitration Act of 1996, which was also made on the very same year when we got the Arbitration Conciliation Act. They had Lord Mustill. He was a judge of a court in England. It was a consultative committee under his chairmanship, and they decided not to adopt the model law in England. However, in the course of the drafting, they have taken inspiration from the model law in certain matters, and the principles of English legislative drafting was adopted, and they had a very workable type of law. Our law is not workable because many words are meant for some other jurisdictions, written by some other people, and not by it is not easy for us to apply it. So they had their own law, which is customized, and we will find they have there is 4 parts in the English Arbitration Act. The part 1 is the most important part. It is the part so as to attract arbitrators across the globe to arbitrate in England. So this part is applicable where the seat of arbitration is England, Wales, or Northern Ireland. This concept of seat is very important in international arbitration. We call it in our act, we will have place of arbitration. We don't hear the word seat in our Arbitration Conciliation Act. It is the place of arbitration. The place of arbitration gives the local court the jurisdiction to assist the arbitration process. Appointment of arbitrator, assistance in taking evidence, extension of time under 29A, 34 challenges, 37 appeals, All these are decided on the basis of where is the place of arbitration. Place and seat are used in a similar. Is not of our interest because it is relating to domestic arbitrations in UK. 3 again deals with recognition and enforcement of. We have part 2 here where we copy the New York Convention. The provisions of New York Convention will be copied. So part 3 is again similar provisions to our part 2, and part contains miscellaneous provisions. It relates to consumer protection and things like that. We are interested only in part 1, where the seat of arbitration is England, Wales, or Northern Ireland. There are 110 sections in 4 parts and 4 schedules. Part 1 will contain general principles which we will be discussing in detail, because the general principles is the principles that should be adopted for interpretation of the provisions, and in any circumstances you will look at these general principles for resolving your doubts and everything. You may require to look into these general principles. Scope and application of the provisions, the arbitration agreement, stay of legal proceedings, commencement of arbitral proceedings, the tribunal and its jurisdiction, arbitration proceedings including court's powers, the award including the court's power regarding appeals and cost. We will find, if you read part 1, you will find that there are several occasions where you can go to court. In India, we don't have such provisions. If you have a challenge against the arbitrator, you cannot go to court. You will have to wait until the arbitration award is passed and you can challenge it under Section 34. The arbitration proceedings will continue. Similarly, in the case of Section 16, you cannot challenge the tribunal and then you cannot go to court. Here, it is not like that. You can go to court. And while going to court, there are several restrictions. Probably the Indian system not permit such court intervention, because they knew that what happens if a case is filed when an arbitration proceedings is initiated. The consequence was the parliament was quite, lawmakers were quite aware as to if such. But in this case, there are a lot of provisions where you can find that court interventions are permitted. But there are sufficient restrictions for moving the court. Now, we will come to the general principles. The general principles is contained in Section 1 of the English Arbitration and Conciliation Act. The provisions of this part are founded on the following principles and shall be construed accordingly. The object of arbitration is to obtain the fair resolution of disputes by an impartial tribunal without unnecessary delay and expenses. This is the principle number 1. The object of arbitration is to obtain the fair resolution of disputes by an impartial tribunal without unnecessary delay or expenses. The party should be free to agree how their disputes are resolved, subject only to such safeguards as are necessary in public interest. And 3, in matters governed by this part, the court should not interfere except as provided by this part. Fair resolution of dispute by an impartial tribunal without unnecessary delay or expenses. Whenever a situation comes before the arbitrator, he has to keep in mind this principle, whether this order will cause unnecessary delay or expenses, whether it will amount to a fair resolution of dispute. So these principles will have to be the guiding principles while interpretation of any provisions, any situation, if you travel through this line in arbitration, things will be easier. The second principle, I think that Imba Vijayan has already spoken at length, that is, the party should be free to agree how their disputes are resolved, subject only to such safeguards as are necessary in the public interest. In arbitration, we have something called party autonomy. And why do people prefer arbitration? People prefer arbitration because they want to know who is going to judge my case. In a litigation scenario, you are going with a construction contract to a sub-judge who has never seen a construction contract document. Your life is going to be very, very difficult, because you will have to teach him what is delay, what is disruption, what is the consequence of delay, what is the consequence of disruption, and such small matters that you will have to teach a sub-judge. But in the case of an arbitration agreement, the parties can agree. You can say that I want a person with such qualification to be the person who is going to resolve this dispute. So party autonomy is very important insofar as I don't want to talk to you much about party autonomy, because this topic has been extensively spoken last time. And in matters of court intervention also, I think that as I have mentioned last time, we will have a session on role of courts exclusively. And Justice Dias, CS Dias has agreed to speak to you about role of courts. So, but I will just give you an understanding about the provisions, and which you may read seriously, so that you will get to understand more about these three principles. The court should not unnecessarily interfere. The party should be able to agree upon the procedure, and the person who should be the arbitrator, the party autonomy should be respected, and there should be a fair resolution of disputes by an impartial tribunal without unnecessary delay and expenses. These are the three principles, general principles of arbitration contained in the English Arbitration Act. So let us look at this from whether the first principle is available in our Conciliation Act. It is available. Section 18 says that equal treatment to parties. Section 12 says that grounds for challenge of an arbitrator. And 13 says about challenge procedure. In 2000 also, the same thing happened. The copying business is inevitable for us. So in 2015, we have added two schedules, Schedule 5 and Schedule 7. Schedule 5 provides for the grounds that give rise to justifiable doubts as to the independence and impartiality of the arbitrator. And Schedule 7 speaks about relationships that makes a person ineligible to be appointed as an arbitrator. So this copying business happened from IBA guidelines on impartiality. Last time, Mr. Imba Vijayan was also mentioning about this. They have two lists. One is the orange list and the red list. Orange list is our Schedule 5. It's a copy of orange list. This orange list speaks about the relationships which gives you a doubt Orange list is contained in Schedule 5. I will share you the certain relationship with the council or the parties will make justifiable doubts as to the independence and impartiality. Under Section 13, I think that you should have to run immediately within 15 days and say that I have come to I have come across a situation where there is a relationship as contained in Schedule 5 in our arbitrator, and therefore the arbitrator should not continue with this arbitration. You cannot sleep over your right. You will have to rush to the arbitrator with an application saying that, gentlemen, please vacate the office, because there is a justifiable doubt that has been created, which is seen in Schedule 5. This is a justifiable doubt that is explained in Schedule 5. That is the orange list that is contained in IBA guidelines. That's a soft law used in international arbitration, which has now been copied by us into the statute itself, which is being given a statutory force. And the 7th schedule, there is another obligation for the arbitrator. If somebody approaches an arbitrator saying that, Advocate Roshan, please be my arbitrator, then he will have to disclose all those things contained in Schedule 5 and 7, saying that I have all these problems that are contained. And that disclosure has to come from the Roshan. So that is again a measure which is adopted to see that this impartiality of the arbitrator is maintained. Then we have Schedule 7. Schedule 7 is a red list. If a person falls in any of the relationships as contained in Schedule 7, he becomes ineligible to become an arbitrator. How can you overcome this? You can overcome this by entering into an agreement with the other side after the dispute has arose. If you can have such an agreement with the other side, this again is to respect the party autonomy. I want a person, but he falls in Schedule 7. So still I want him as the arbitrator. So you can enter into an agreement with the other side after the dispute has arose. Why this after this dispute has arose? This after the dispute has a very important relevance. At the time of marriage, all relationships are good. At the time of divorce, things goes bad. At the time of entering into contract, everybody will be happy. At the time when the dispute arises, things will go bad. People will not agree for anything in either of these circumstances. Therefore, this clause is specifically included in Section 12 that you should have to enter into an agreement after the dispute has arose if suppose the relationship falls under Schedule 7. And unnecessary delay and expenses part. This is impartial arbitrator. How to make impartial arbitrator? We have Section 12, 13, 5, Schedule 5, 6, 7. These measures are there in the Arbitration Conciliation Act in order to see the first principle is in the English Arbitration Act being complied with.